Welcome back on our series on estate planning. With this video, we're going to talk about a will, what it can do, what it can't do, and how it actually works in Arkansas. I think most folks have probably heard about a will from TV and movies, or maybe you went through it in your personal life. But in a nutshell, the will is a fairly simple document. It's just going to write out the instructions where you want your assets to go once you pass away. And so we're going to figure out what's going to happen to your house, what's going to happen to your other real estate, your bank accounts, and it can get down to the specifics of where you want your clothes, jewelry. Depending on how complex the estate is, the will could be several pages, up to 12 pages long. We get a couple of witnesses present, and we get it notarized to make sure it's valid. And then the will is just sitting there until you pass away. In a perfect world, we're going to do this early when you're in good health, everything's fine, and then it's not actually going to get used until several years later. For the will to take effect, once you pass away, now the family member has to come in and open up that probate process. And we talked about probate in an earlier video, but now it's almost always whoever was named as the executor, they're going to go file that probate proceeding. It's going to start everything up. They're going to pay the lawyer, and then working through all the steps of probate, doing the publications, doing the notices, doing the inventory of assets and all that. And then they're going to petition to the court, hey, here's what the will says. So here's the distribution we're getting in mind. And the judge is going to oversee all of that. Now, what can happen in this process? This is where folks can get pretty ugly at times. Usually whoever got shortchanged at the will, they're going to pop up in the probate proceeding, try to challenge the will. They're going to say, granddaddy never would have cut me out like that. It's fraudulent if they had it forged. And sometimes families can be in a legal fight for years on end over it. But at the end of it, there's going to be a final order doing the final distribution. If there was any real estate to deal with, then a deed will come out of the estate to whoever it was going to, and then eventually the estate will be closed once all those assets have been distributed, creditors paid off, and just wrapping up the estate in that way. In a nutshell, the will is the simplest and cheapest instrument for us to create, but it's going to put a burden on your family after the fact, after you passed away. So if we're wanting to relieve your family of what's going to go on after you pass, then we're going to talk about the trust, which is going to be on next video. There's nothing wrong with the will, and some folks, after hearing about a trust, they just don't want to do it. They want to go the will route. That's fine. Just understand that we're going to have to deal with probate at some point once you passed away to get all this completed. Thanks.